give up. Got too little time, I'ma live up. Head down, push forward through the tough times, cause anything worth doing is a tough climb.
Pennsylvania, Mafia rules apply. Habitability, condemnation, evictions, and occupancy rules impact on landlord during COVID. The story continues.
Part 2.
Imagine a 2-unit rental that had 2 bad tenants during COVID which could not be evicted. Said property is not my own. I just did my best to help the owner. Tenants were forcefully evicted by city when they allegedly condemned 1 unit May 2022, then the 2nd unit April 2023. Based on landlord's understanding, property was designated not habitable, never condemned, but learned city was holding it to condemned designation standards July 2024 when she lost her signed sale offer for the property 20 days ago because it is the best property in the area according to Zillow market data. This is evidenced in August 20th, 2024 proceedings when I asked questions clarifying dates and designations because I was also confused by what was occurring and why. Inspection reports allegedly try to demonstrate pest, sanitation, and damages. Funny thing is the tenants literally punched holes in the walls, never disposed of trash, and littered the exterior. Once the tenants' personal belongings were removed by April 2022, both units were ready for occupancy by June 1st, 2023, except for the fact owner did not realize. Mafia rules apply. Good luck getting a fair resolution. Here is an analysis of my findings based on my background in compliance and doing inspections for a living. Here I clarify things in hopes you can avoid being taken advantage of as this owner was and still is. In court today, the judge decided that even though property never was or is or will be a boarding house, the owner would be fined $500 for boarding house violations. Then $1,000 for occupancy violations when it was allegedly condemned, although inspection report city completed less than 30 days before the moment of contention literally states. Section 401 to Section 403 light and or ventilation violations no. Section 404 occupancy violations no. Section 501 to 507 plumbing and drainage violations
No.
Section 501 to 507 plumbing fixtures and drainage violations
No.
Section 108 unsafe unsanitary property, unfit for occupancy / condemned no. Not sure how a judge made his determinations based on this inspection report determinations by city inspectors and fact property was never a boarding house. Instead, single-family dwelling use, which is a permittable use. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. As a normal person you would think, no violation exists, right? Don't forget, Mafia rules apply. Let's dive into the facts. PS photos of the property today, August 21st, 2024, will be sprinkled throughout this article as visuals. Remember, occupancy certificate received yesterday and property received an offer to purchase the property for $230,000 and $20,000 plus in closing costs just 20 days ago. Insanity is this property is among the best in the city and in great condition to gain multiple sale offers this year. To get to today's condition property is in today. Owner lost over $81,000 in loss of use rent plus utilities January 2023 through today, which does not count all the months in 2022 the first unit was condemned. Imagine the condition the property would be in if we did not lose over $81,000 instead had that money to put into maintenance or improvements.
City does not know simple math.
Common sense. You find rentals, then they have less money for repairs and can't afford to remedy issues without much undue pain and suffering. This property is owned by an LLC with no income because no rents, property manager, and accrued debts to repeatedly address cosmetic repairs the city required. Habitability standards defined. Condemnation occurs due to severe structural deficiencies, safety hazards, or violations of building codes and ordinances that present significant risks such as extensive structural damage, fire damage, presence of hazardous materials, or violations of zoning regulations, which pose significant risks to occupants or the public. Structure of the property was never condemnable and always habitable. There were never serious or significant safety hazards or zoning violations. Condemnation means the property is deemed uninhabitable or otherwise unsuitable for use or occupancy. And in accordance with Section 20-6 Certification Part B, a property subject to condemnation has a determination of a public nuisance and is a blighted property. By definition, a public nuisance is an act, condition, or thing that is harmful to the public at large or a significant portion of it and interferes with the community's rights. importantly impacts a broader community and is not a private nuisance, which affects specific individuals or properties. Examples: factory emitting pollutants. By definition, a blighted property refers to a building or land in a state of significant disrepair or neglect, making it detrimental to the surrounding community. It is often associated with issues like abandonment, vandalism, and safety hazards. Common characteristics of blighted properties include broken windows, collapsing structures, overgrown vegetation, and signs of vandalism. These properties can lead to decreased property values in the area and attract criminal activities. Determining blight involves assessing the property's condition and its impact on the surrounding community. Once declared blighted, the property may be subject to government intervention such as condemnation, demolition, or redevelopment initiatives. Section 20(4) states a blighted property shall be a public nuisance due to physical condition or use, deemed to be a danger to public health, safety, and welfare, or public nuisance, or physical condition, use, or occupancy, including abandoned water wells, shafts, basements, excavations, and unsafe fences or other structures, or which contains an unauthorized entry, unsafe equipment, or other safety risk. Condemned properties are dilapidated, unsanitary, unsafe, or vermin-infested condition, or that is lacking in the facilities and equipment required by law. Property is never a public nuisance or blight in accordance with codes and standards. Property was never a nuisance activity in accordance with Section 326(3) of our municipality codes and standards. Section 451(1) evidences the capacity to be habitable, landscaping maintained, have utilities function, blinds exist, and property is furnished. This means this property is habitable by definition. Section 165(8) states, building and structures are maintained when they do not present a health and/or safety hazard to surrounding properties and to the general populace. This means this property is habitable by definition. Never is property deteriorated to be unable to house people and does not constitute a severe health and/or safety hazard. Never is property ill-maintained or neglected. See comparable sand market data, sales offers, etc. Problem was, landlord had bad tenants. Once they were evicted, normal maintenance to prepare for next tenant was all that was needed. Section 165 Part 4 clarifies dangerous buildings as having defects where interior walls or structural members lean buckle. Foundation shows 33% plus deterioration/damage. 50% plus deterioration of non-supporting members. Improper distribution of loads on floors or roofs, thus not reasonably safe. Fire, wind, or other cause danger to life safety or general health. Property is so damaged, dilapidated, unsafe, unsanitary, vermin infested, or fails to provide amenities essential for decent living. Likely to cause sickness or disease, so as to cause injury to health safety or general welfare. Parts attached to home may fall or injure property or public. Lack of illumination, ventilation, or sanitation facilities making property unsafe, unsanitary, or dangerous. Violations to building code, fire prevention code / or other. The property was never a dangerous building in accordance with this section. Section 248(6) Residential rental units F. 4. Code enforcement official or inspector shall provide post-inspection report indicating full compliance or list of any deficiencies. Here officials repeatedly failed to provide a list for landlord to address and repeatedly failed to provide inspection reports for all inspections that occurred on property as 20+ occurred January 2023 to present. Yes, unlawful frequent searches and seizures. Here inspection reports list cosmetic issues and add new items for resolution with each inspection. More than 20 inspection walkthroughs completed through present just this year where officials do not write inspection reports for all visits because they know that would evidence their unlawful actions. Also, the fact they do not write reports for all visits means you can't get a list of things to resolve. This comes from someone who performs inspections for a living and ensures compliance, utilizing my master's from Vermont Law School and other credentials. Thus, difficult to situation because firstly resolving things is hard, secondly resolving things never required in written reports means you are doing repairs without oversight as to whether that request was even lawful in general. That is why when they told landlord to paint siding last week, I emailed them photos of it completed to document they request cosmetic painting of exterior siding to gain occupancy certificate and habitability designation for the property. Sounds hilarious. Basically, according to city, the property is not livable if the front siding is not painted. Looks like my neighbor should be condemned right now too. Be sure to stick around for photos shared at the end of my Medium.com article written on this topic. All actual photos for this whole thing are all provided within the Medium article, which can be searched. Have written reports, see emails evidencing multiple visits, i.e. for building permit, inspector, etc. According to this municipality, condemnation and habitability are interchangeably the same thing. An occupancy certificate must be received for the property to be livable. Habitability standards. Defined. Overall habitability pertains to health, safety, and structural integrity. If the property meets these standards, i.e. has functional plumbing, electricity, and is free from severe safety hazards, it should not be declared uninhabitable. Case law. Javins v. First National Realty Corporation, 428 F.2d 1071, DCCIR 1970, established that tenants have the right to a habitable dwelling, setting a precedent that habitability depends on the property meeting certain basic living conditions. Importantly, if those conditions are met, the property is considered habitable. Structural integrity and safety. This pertains to a condition of being structurally sound with no serious issues like unstable foundations, collapsing roofs, or other conditions. Case law. Park West Management Corporation v. Mitchell, 391 and E.2d 1288, New York 1979. New York Court of Appeals found that a landlord's failure to maintain the structural integrity of a building, where ceiling collapses and exposed electrical wiring, breached the implied warranty of habitability. Yes, all is functioning in great condition, never any exposed wiring, ceiling collapses, etc., and the roof was brand new before condemnation designations. Be sure to slow the video speed settings if you want to watch the video in a slower pace. 2. Absence of infestations. This pertains to pests such as rats, roaches, or bedbugs due to serious health risks. Case law. Kettner v. Buckeye State Mutual Insurance Company, 2013, Ohio. 5077, Ohio Court App. 2013 Ohio Court of Appeals ruled that a property infested with bedbugs, where the landlord failed to take adequate measures to address the infestation, could be considered uninhabitable. Property never has any evidence of one or more actual pests, let alone any infestations inside dwelling. Landlord also implement regular pest control actions for this property. By law, just because city broadly has pest issue does not mean pests reside inside the dwellings. See emails and Roy eviction court transcripts evidencing never any issues within a court of law and sworn testimony, even though tenant in that hearing was defending against damages landlord was filing against him. 2. Adequate heating and ventilation. Property provides safe and comfortable dwelling for tenants. Case law. Hilder v. St. Peter, 478 A.2d 202, VT 1984. Adequate heating is important. Yes, all is functioning in great condition. 4. Safe and functional plumbing, i.e. safe and reliable water supply systems, access to hot and cold water, and properly functioning waste sewage disposal. Case law. Marini v. Ireland, 265 A.2d 526, NJ 1970. New Jersey Supreme Court held landlord's responsibility to repair broken plumbing constituted a breach of the implied warranty of habitability. Yes, all is functioning in great condition, never any leaks or broken plumbing. All systems function in any inspection reports. 5. Safe functional electrical systems, i.e. exposed wiring, frequent outages, or systems that pose fire hazards can render a property uninhabitable. Case law. Johnson v. Scandia Associates Incorporated, 717 A.2d 24, Con 1998. Connecticut Supreme Court held that persistent electrical issues, including frequent power outages and exposed wires, could justify a finding of uninhabitability, particularly where the landlord failed to make timely repairs. Yes, all is functioning in great condition, never any exposed wiring, outage, or fire hazard potentials, etc. 6. Proper sanitation and waste disposal, i.e. proper sanitation facilities, including functioning toilet, waste disposal systems, no accumulation of waste or sewage backups that can make a property unsafe and uninhabitable. Case law. Doe v. New York City Housing Authority, 920 N. White, S.2d10, New York App. DIV 2011 Court found chronic issues with sewage backups in a public housing unit, which the housing authority failed to address, could render the property uninhabitable. Yes, all is functioning in great condition. 7. Adequate protection from the elements, i.e. roof that doesn't leak, windows that close properly, and walls that insulate effectively against the cold and heat. Case law. Berman and Sons Incorporated v. Jefferson, 343 and W.2D 240, Wisconsin 1984 Wisconsin Supreme Court held that a leaky roof led to water damage and mold, breached the implied warranty of habitability, making the property uninhabitable. Yes, all is functioning in great condition. New roof, never any leaks, windows closed, walls insulated. 8. Absence of toxic or hazardous materials, i.e. lead paint, asbestos, or mold. These substances can pose serious health risks, especially to children, and make a property uninhabitable. Yes, upon purchasing property, no lead paint, asbestos, or mold issues existed, nor were any disclosed. Never do tests, samples, or other evidence any lead, mold, or asbestos. American Water sampled and evidenced no lead exposures in our water supply on or around November 2023. Never are exposure over permissible exposure limits, PLs, documented for mold, asbestos, lead, or other issues. Property in great condition. Both units professionally painted entirety. Never any asbestos, lead, mold, or other exposure issues. Know that so no reason to remediate X, i.e. paint or silicone, but city required these actions regardless of no actual tests proving any issues over permissible exposure levels actually existing for any of these issues. Case law, Green v. Superior Court, 517 P.2D 1168, Cal. 1974 California Supreme Court established presence of hazardous conditions such as mold and lead paint, which were not addressed by the landlord, constituted a breach of the implied warranty of habitability. As an aside, in the realm of law, landlords have the responsibility and ability to address issues. If reasonable efforts are made to address issues, the landlord may be deemed to be remediating all in a lawful manner and no liability may exist. It is when the landlord takes no action or is deemed to not take sufficient, timely, reasonable action where you have legal liability. Here this landlord does remediate issues, and if they had rental income, maintenance would be easier and quicker. Due to COVID, tenants stopped paying rent and were impossible to evict. Then city condemned one unit, then the other unit, which led to further loss of use rent and utility payments ongoingly through yesterday's occupancy approval. 9. Adequate lighting, i.e. both natural and artificial, is necessary for a property to be considered habitable. Lack of lighting can contribute to unsafe conditions and affect the health and well-being of occupants. Yes, property has windows in all rooms, ceiling lights, and lamps. Unlawfully code-stated lamps were insufficient, and lighting must be wired to all ceilings of all rooms, and this was an abusive, unlawful determination. Instead, only lamps are required by law. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. Case law, Boston Housing Authority v. Hemingway, 293 and E.2D 831, Massachusetts, 1973 Massachusetts Supreme Judicial Court recognized that lack of adequate lighting, among other issues, could render a property uninhabitable under the implied warranty of habitability. 10. Compliance with health and safety regulations listed above 1 to 9. Violations of these regulations can result in the property being deemed uninhabitable. Case law, Javins v. First National Realty Corporation, 428 F.2D 1071, DCCIR, 1970. This landmark case established that housing code violations that affect health and safety can breach the implied warranty of habitability. Specifically, numerous housing code violations including heating, plumbing, and sanitation. The court held that substantial violations of housing codes that affect health and safety can constitute a breach of this implied warranty. Properties are to be safe and livable. Yes, property safe and in great condition. Yes, property is safe and livable, never numerous, serious, significant, or substantial violations. In summary, landlord demonstrates that the property meets these legal standards, no substantial, serious, or numerous issue exists, and any deficiencies listed by officials regardless of relevance have been addressed. Property is well maintained and in superior condition to properties throughout the city and nearby. Property provides basic living standards, superior condition of property, and it provides a safe and healthy living environment for tenants. If the property complies with local building codes, health and safety regulations, and housing standards, it should not be condemned or deemed uninhabitable. Landlord's compliance demonstrates that the property meets the legal requirements for habitation. Case law, Wells v. Housing Authority of the City of Wilmington, 601S, E.2D 345, and C. 2004. The court found that properties meeting local code requirements were not subject to condemnation. See property values. $244,000 property value for our property, while of the 25 closest properties nearby, valuations by Zillow are $10,000, $10,000, $10,000, $96,000, $105,000, $111,000, $114,000, $117,000, $121,000, $129,000, $130,000, $136,000, $142,000, $147,000, $157,000, $166,000, where only two other properties exceed $200,000, but only at $206,000 and $204,000. Landlord's property was purchased for $50,000 December 20th, 2020. Now market value is $244,000 according to Zillow, where due to condemnation city would not lift. Signed sale, offer for $230,000 plus over $20,000 in closing costs could not occur. Based on all these damages, we have a great lawsuit if there is an attorney available to try this case on contingency, as landlord does not have money due to the whole thing. As an aside, the city official in charge of handling the condemnation was supervising the official who ran over property owner with a truck, causing fractures in foot or feet, knee surgeries, physical therapy, and/or torn rotator cuff. Separately, this safe official caused landlord to become homeless in 2014 for another property, so I deem this all to be ongoing retaliatory abusive actions to try to take another property from this landlord. Here, the property has no mortgage, which is the only reason why cosmetic repairs can be placed on credit cards for resolution. No income, but also no mortgage, yes, utilities means a slow and steady death. As evidenced, with landlord's property purchase, only did property suffer into highly neglect, then shot way up in value from the moment of purchase on. Condemnable? Nope. Instead, just a normal eviction, cleanup, maintenance, then find new tenants situation. Never was property condemnable in my opinion. Comparative conditions of neighboring properties. This is an important one. If neighboring properties are in similar or worse condition and have not been condemned, it may be argued that the property in question is being unfairly targeted. This could suggest arbitrary or discriminatory enforcement. Case law, Yiqua versus Hopkins, 118 U.S. 356, 1886. The Supreme Court held that discriminatory enforcement of regulations violates the Equal Protection Clause, even if the regulations themselves are neutral. Here, a property owner is subjected to more frequent or harsher inspections compared to others. The Fourth Amendment protects against unreasonable searches and seizures, which can apply to inspections of private property. Inspections are generally permitted, but excessively frequent inspections could raise Fourth Amendment concerns if they are seen as unreasonable or invasive. Yes, inspections are numerous, frequent, and invasive. New violations are being added unfairly. New cosmetic or non-habitability items listed for landlord to address ongoingly and frequently without oversight. Here, equal protection clauses under the 14th Amendment of the U.S. Constitution are breached. Here, this prevents the government from applying laws or regulations in a discriminatory or arbitrary manner. For this case, solitarily Chinese landlords were required permits for certain work. My findings for the landlord include that permits were required for the landlord for things no permit is normally needed, i.e. flooring, electrical, plumbing walkthrough, cement skirt along exterior/pre-existing sidewalk repair, exterior of chimney cosmetic mortar beautification, pre-existing with similar materials within existing footprint accessory wall repair where city trash truck hit and run damage caused the damages, etc. Yes, city caused these damages and we await reimbursement for the damages. This action is something city does strategically. Mafia rules apply to cause condemnation situations so they can take properties from owners. Smash the like button for the YouTube algorithm. Interesting how this retaliatory action applies here to this landlord. Case law, Cleburne versus Cleburne Living Center, 473 U.S. 432, 1985. Cleburne denied a special use permit for a group home for the mentally disabled, although similar homes for other groups were permitted. Supreme Court found that the denial was based on irrational prejudice, violating the Equal Protection Clause. My findings for the landlord is that permits were required, denied, stop work orders placed, and violations pervasively numerous and frequent, but not serious or significant to justify condemnation as irrational or discriminatory reasons for the designation, and the act of targeting individuals is in violation of the Equal Protection Clause. Here we have grounds for discriminatory enforcement actions. If neighboring properties in similar or worse conditions are not subject to the same treatment, the condemnation violates the Equal Protection Clause. Such arguments can be bolstered by presenting evidence of comparable conditions, communications with authorities, and the absence of a rational basis for the differential treatment. All is relevant to this property. See sale offer, comparables, emails, and photos for neighboring properties. Neighboring properties in similar or worse condition and never succumb to designation, and historically this property at $50,000 valuations in poor condition, never a designation until years later after roof, $34K plus, flooring, $10K plus, fencing, $1K plus, retaining wall, $1,700 plus $500 plus, $280 materials, etc. spent on renovations, improvements, or past repairs before condemnation. See comparables for unlawful enforcement actions provided. See photos, emails, exhibits, etc. provided. Zillow market data and details, i.e. provided via email and via Zillow website for property address. See today's data for both units, as it is a 2-unit building. The property was purchased at $50,000 price December 2020, historically never condemned or deemed not habitable before 2022 designation. Never did owner receive any warnings, violations, or citations for any issues before the condemnation designation was placed. This by itself evidences the landlord was target, and the designation was always retaliatory instead of justifiable. Normally, an owner would have historical issues. Here, this property never had issues, just a condemnation that persisted 2022 to present due to city officials' delay of justice and improper implementation of the condemnation process. Then also consider due process was never upheld throughout this process. See multiple sale offers. $230,000 plus $20,000 closing costs, July 2024 sale, offer accepted. Insane appreciation of 460% December 2020 to present, $50,000 versus $244,000 Zillow valuation today. $180,000 sale, offer received around November 2023. Insane appreciation of 460% December 2020 to present. Emails reveal inconsistent or arbitrary application of standards, i.e. March 9, 2024 at 2:57 email, February 2, 2024 at 10:12 email, which evidences they told landlord to sweep dirt floor basement, clean and empty clean sink, and not maintain her clothing inside the closet in one of the units, which I personally observed myself within the February 12, 2024 inspection, which I video recorded in full. Landlord is a disabled female who requires clothing due to medical issues, and it was discriminatory for him to say these things. Separately, very abusive and retaliatory, which is unlawful. As I clarified in an email summarizing my observations for that inspection, the landlord is by law allowed personal property on their property. They are allowed personal property in closets, in basements, and anywhere they want. See February 1st, 2024, 9:43 email. See January 16th, 2024 at 9:35. At this point, you may be thinking, Mafia rules apply. Any reasonable person would agree unlawful actions are pervasively at issue here, and I am only a third-party observer with no ownership of any property in this locality. Instead, manage 19+ properties elsewhere. Never have I seen such abusive, unlawful actions against a landlord, except for where this all started in 2014 when this code enforcement officer falsified issues to get this landlord homeless and property condemned and demolished. An empty, overgrown lot still today, a decade later. Presently best in the area, market valuation for this property. The property is in great condition. As evidenced, tens of thousands of dollars higher value than the closest 25 properties, where this property literally has the highest value with nothing coming close. See above image from Zillow dated August 19, 2024, just before proceedings and same-day occupancy certificate was received. It is unlawful for city officials to only give occupancy certificate after property is the highest valued property in the area. Also, not lawful for the disabled landlord to be forced to paint siding front and back of home to gain occupancy approval as their adjacent neighbor has discolored siding in worse or similar condition and is not condemned. See photos provided. Retaliatory, does it not look when city officials provide occupancy certificate only one day before court date proceedings on the 20th, where leading up to the court date I documented in emails to the city officials their continued numerous requests for cosmetic items for resolution. I find it highly likely the city officials provided the occupancy certificate strategically delaying justice until the day before their court date only to take advantage of the landlord and with strategic intent. Also, the city knows that the city cannot take the property for demolition if it is of less cost to perform repairs up to 50% of the market value. Here this would mean over $115,000 in repairs shall occur before any consideration of demolition action being reasonable. As Zillow documents the best in the area market value and publicly available superior condition via evidenced photos on the website and enclosed here, the city at this point realized demolition would be difficult, so they decided to lift the condemnation, knowing they could no longer strong-arm landlord because I, a third-party individual with no properties in this locality, was holding them accountable for their actions which would never be viable in other cities. Yes, I manage properties 13 in Florida, 1 in Indiana, 7 in Pennsylvania. Never have I seen such abusive behavior. My involvement here is only started because this city code enforcement officer called an electrician on my permit for my property outside his jurisdiction in another locality because this landlord was helping me manage repairs for my property in that separate locality. I, at that point of being informed, he harassed my electrician in retaliation against landlord, told me he was targeting this landlord since 2022 when the harassment occurred, which forced me to quit my Department of Homeland Security job and come from Saipan to Pennsylvania to resolve matters for my locality 20-minute drive away. Ironic. Condemnation started in 2022 around the same time as this harassment. Ironic. Condemnation occurred after taking a property from this landlord and making them homeless previously. Ironic. When the property was ill-maintained and valued at $50,000 for a 2-unit property, $25,000 per unit, the property was never condemned against any of the previous owners. Soon after this landlord returned to this locality with ownership of this property December 2020, this property was condemned as the official knew they could strong-arm her again. Had I not started to oversee all actions and begin documenting all in emails to the officials, this best in the city property would likely be in process to be demolished by now. Ironically, never do actual condemnable issues exist. The closest thing I could find to be condemnable is the need for the accessory wall repairs, but the city trash truck hit and run to cause that. Other than this, no other item on any inspection reports are actually condemnable because no actual pests inside the dwellings were ever evidenced. Never any mold actually tested and confirmed. Never is cleanliness justifiable by itself when it is tenant-caused and landlord could not evict tenants due to COVID and only able to be remedied after eviction because removal of tenant personal property is not lawful. Tenant cleaning and move-out repairs are normal, not a condemnable circumstance, normally. Seems retaliatory to me. Mafia rules may apply. Ironic. Condemnation occurred after code enforcement officer here's subordinate hit and run landlord with a truck causing her invasive, pervasive medical damages. She still does therapy and medical visits for today. Yes, that employee was terminated. I argue the superior, who is the code officer managing this landlord's condemnation, should be investigated for unlawful actions and improper implementation of code of ethics as licenses or credentials require of him. As stated in emails post-December and February inspections, their licenses should be suspended for breach of code of ethics they are to abide by, or similar words. Smash the like button for the YouTube algorithm. To a reasonable person, this looks both livable and best in the area just as the market data evidences. These images are the status of the property the same day occupancy certificate is received and 1 day before court proceedings with the upper level court. March 8th. 2024, 542 email, city condemns it not when at $50K value with previous owner and not maintained. Instead when house has new roof, new floors and over $100,000 value. City asks landlord to paint corner of a closet when entire closet and home was professionally painted. Cosmetic. See email December 20th, 2023 at 10:10, according to the methodologies and actions of officials. Nearby properties should be deemed uninhabitable and condemned based on their similar or worse condition. Thus I am awaiting lawful, fair, amicable treatment for all residents because as it stands, there is no rhyme or justifiable reason for this property to not be provided its habitability certificate. Question: why are our neighbors' homes habitable based on objects being on their porch, unsanitary, and everywhere? Landlord has no freedom to exist in here, might as well not exist because if we do have personal belongings or an empty sink, the city code enforcement or inspection officials may deem property not habitable. See April 28th, 2023 at 9:41 email etc. Yes, inspector required landlord clean empty sink. Yes, on Christmas my Ohio Airbnb should have been condemned for its worst condition, but we paid thousands to stay there. It also had lamps and no ceiling lights. This is a double violation and highly condemnable offense for had it been in Pennsylvania, where our landlord resides. Then again, I guess owner would be fine because they are not this female disabled landlord who they previously made homeless before. Section 248 Part 10 clarifies violation or violations that create such a hazard to imminent threat to public health, safety, and welfare. This section never applies to the property at question. Section 326 Part 2 chronic nuisance is present where grave health, safety, and welfare concerns have a tremendous negative impact upon the quality of life, safety, and health of the neighborhoods. Chronic nuisance properties are a financial burden to the city. This section never applies to the property at question. Section 165 Part 4 infestation insects, rodents, or other pests. This section never applies to the property at question. No evidence of actual pests inside the dwelling exists. Instead, just general uncleanliness due to tenants which could not be remedied due to COVID until tenant was evicted. Normally, a landlord would have reasonable time to personally resolve tenant issues like this outside of a condemnation process. They just get a dumpster, maintenance property, and find new better tenant. Landlord here never caused the violations. The officials never cared that landlord did not cause issues and never allowed landlord reasonable time to get property cleaned up from tenant-caused filth. Also consider, both tenants stopped paying rent. Officials did not care that landlord was not receiving rents, was impacted by COVID-19, had no employment income, and never caused the issues the city wanted resolved. Fair time and consideration of circumstances within COVID was never considered. Level up your life. Follow us on Medium to unlock our secrets. Subscribe to us on YouTube. Interestingly, it is cited that within COVID a property can be condemned, but there are several factors and protections may exist. Properties can be condemned if they pose a significant risk to public health or safety. This includes severe issues like structural instability, severe mold infestations, lack of basic utilities, or other dangerous conditions. COVID-19 specific protections applicable here include SB 91. The COVID-19 Tenant Relief Act states that a tenant may be protected from eviction for rent due between September 1st, 2020 and June 30th, 2021, if landlord provides a signed and dated form declaration each month and pay a total of 25% of the rent for that 10-month period by June 30th, 2021. Here, tenants never did this and did not pay rent repeatedly, which landlords still received no remedy today. Landlord had financial suffering due to no rents receipt. Then city officials condemned both units, without condemnable just reason leading to no rents 2022 to present. April 2023 officials failed to provide due justice to allow landlord to remedy alleged violations with posted stop work order on door. Then again with May decline of permits, where through present officials never approved any permits and permits were never justifiable because the application included cosmetic or normally not permittable work. Officials here required permits for flooring, mortar beautification, repair to pre-existing accessory wall with same footprint and materials all caused by city dumpster truck, plumbing, electrical, heating walkthrough, but no actual work unless needed as all systems function well with no leaks, no exposed wiring or other issues. Add inches of skirt around perimeter of building, pre-existing sidewalk repair, and chimney beautification where inspector deemed it was not at any risk of puncture, and only cosmetic work. A permit is not normally needed for other municipalities I oversee work for. Protections against eviction due to non-payment of rent, but they did not generally protect landlords. This in my eyes is unjust. What happened to this landlord is unjust. Landlord has angelic intentions where intent is a significant consideration within judicial systems. Landlord never caused the alleged violations, lost rental income from unpaying tenants, and officials condemn property unjustifiably 2022 through present delaying justice the entire time and always seeking demolition instead of working with the landlord to allow violations to be remedied. Sounds like a farce. My exact words within the proceedings. I was so upset by my observations of the Mafia rules apply scenario I was seeing. Judge decided the officials did not need to provide documentation about any of their arguments. Landlord literally can't even have fair hearing because nothing is publicly available. Officials do not give you documentation before proceedings. Discovery was not provided, and judge allows lawyer and officials to give no documents to clarify the issue we are there for. Unfair hearing. Justice was never possible. Judge disregarded relevant, highly vital evidence. There was never any fair process from the start. Back to clarifying pest issues. The officials never evidenced that an actual pest infestation actually exists inside dwelling, let alone any actual infestation existing in general. Landlord performs regular preventative pest control actions. Tenants evidenced never any pest issues within official court of law eviction court hearing proceedings for Roy IEC May 18, 2023, 10:08 email stating, there are no mice, rats, or structural safety issues that would lead to a valid eviction, condemning, or demolish of building, etc. Government burden of proof. When a city seeks to condemn a property, it must provide sufficient evidence to demonstrate that the property itself is infested to a degree that it poses a significant health or safety risk. By law, mere presence of pests in a city does not automatically mean a property is uninhabitable unless the infestation is inside the property and affects the tenant's health or safety. City must provide clear and specific evidence that the property in question is infested. Case law. Armstrong versus United States, 364 U.S. 40, 1960 found government must provide just compensation when condemning property. It also highlighted the importance of clear evidence and legal justification for taking such actions. If a city attempts to condemn a property based on a presumed pest problem, the owner may challenge the condemnation by demanding that the government meet its burden of proof. Without clear evidence of infestation on the specific property, the condemnation could be considered arbitrary or unjustified. See PDF page 20 evidencing eviction court transcripts evidence never any pests. Personal property, debris, and trash. Landlords are unable to remove tenant personal property, debris, clutter, or trash owned by the tenant where tenant refuses to remove or relocate their personal property. It is the tenant's responsibility to keep their rented premises in a clean and safe condition in accordance with lease agreement. Landlords generally do not have the right to remove or relocate a tenant's personal property without following due process, such as obtaining a court order through eviction proceedings. Landlord could not address certain issues until tenant was evicted and personal property was removed. Due process protections for tenants mean that a landlord is unable to remove tenant trash or personal property without violating the tenant's property rights, which require due process, i.e. formal eviction proceedings. Case law. Lindsay versus Normet, 405 U.S. 56, 1972. Landlords cannot take unilateral actions that deprive tenants of their property without following legal procedures. Sounds similar to the due process supposed to be provided to this landlord, which never occurred. Yes, Mafia rules apply. Section 165, Part 6A to D, same official condemned and demolished 2014 property to make this landlord homeless, although never sufficiently fulfilling Section 165, Part 6A to D. Instead, property was never dangerous, actively lived in, always reparable, never dangerous to health, safety, or general welfare. Dangerous building is 50% plus damaged, decayed, or deteriorated, and unrepairable. The cost of repairs exceeds 50% the market value of the building, where officials force landlord out of home improperly. See inspection reports never exist before landlord was forced out of property. Instead, reports are after landlord was forced out and property vacated for prolonged period of no maintenance, precedent of improper actions. Efforts to mitigate. Landlord made reasonable efforts to address the issue, such as notifying the tenant of the violations, requesting the removal of trash, seeking assistance from local authorities, or addressing all through present. Again, intent is important normally within a court of law. Judge within proceedings allowed me to present the city's case, but never allowed us to present our case, and cut me off and disallowed further talking, then decided guilty against the landlord with literally practically none of this content communicated, because it was never a fair process from the start. I am also not a licensed attorney. As clarified earlier, the judge decided $500 violation for a boarding house use of property that never exists December 2020 to present, and will never exist as long as I am alive if I had to bet on it, because landlord always has and will always have a single family use dwelling where one family houses each unit privately feeding themselves and doing their own laundry, and never sharing the unit with other persons, or they're subject to be evicted because this is against lease agreement terms, for them to sublet the property to other people. It is literally by law never a viable use for landlord or tenants. Landlord received not just a guilty decision. Unjustifiably, they received the maximum allowable fine of $1,000 for occupancy and $500 for boarding house. Landlord needs an attorney. She is getting steamrolled. Mafia rules apply. All I can say, at least the occupancy certificate was received August 19, 2024. Well, in this municipality, received is hypothetical because they tell you are good and mail you the documentation instead of providing you the documentation for your records on site in person the moment you pass the inspection. Again, as someone who performs inspections for a living, it is only unjust for the inspector to provide no documentation on site the moment the inspection passed. There should be a document given to the landlord at that time. Yes, they can mail inspection report eventually to landlord in their slow, unfair way like they normally do, but it is unjust and unreasonable for nothing in writing approving occupancy certificate in person at that time. They said all, yes, all is recorded on video camera, but who is to say Mafia rules apply, and they lied just to mess with you. You, the landlord, should never be proffered the situation of trusting words. Next day in court, I asked officials, occupancy certificate is approved, right? Officials said, yes, you should receive it in mail soon. Then, at end of proceeding, I stated landlord did address all and occupancy received yesterday. Judge here cut me off, never allowed us to talk, and decided in favor of officials for the maximum fine. Yes, Mafia rules apply. Normally, the fine is comparable to the crime. I literally moments before evidence the inspection report February 12, 2024 evidenced. Section 404 occupancy violations no. Section 108 unsafe unsanitary property, unfit for occupancy / condemned no. Basically, this proves the landlord had just reason to think property was not condemned and allowable to rent. Also proves the property was not actually unfit for occupancy or condemned based on its condition and should have been provided an occupancy certificate at that time if not earlier. But of course, when Mafia rules apply, best decision for a judge would definitely be to go with maximizing the fine available against the landlord. Sarcasm here. Yes, we just determined the property was not in a significant, severe, serious state of neglect and instead livable. We should definitely give the landlord a maximum fine for renting to a long-term tenant who works in the area for his employer. The officials literally proved the property was livable and fit for occupancy when they submitted to evidence an Airbnb receipt for $405 for a guest to stay at the property, where he had agreed to sign a long-term lease with landlord in text messages. It is only reasonable for a habitable, livable, occupiable property to be listed on Airbnb. This property was listed on Airbnb just after the February 12, 2024 inspection where I took the photos myself. I thought the property was livable, not a condemnable property, habitable, and always had the essential amenities to live in addition to even had more because it was fully furnished with couches, beds, appliances, Keurig, office desk, utensils, plates, bowls, towels, toilet paper, soap, shampoo, conditioner, trash can, trash bags, blankets, cleaning supplies, broom, mop, and more. Fun fact, my property 20 minutes away only allows 1 month rentals or longer. I gain tenants for my single-family dwelling through Airbnb platform website, and my guests only get approved to stay at my property if the stay is in accordance with local ordinances, codes, and standards. Here, I find landlord did nothing wrong based on the circumstances. The issues were all caused by tenants. Landlord only addressed items. Instead, her situation is unjust and evidence failures in our legal system. This is a systemic issue. This is why I am here drafting this all for you now. I hope you gain insights and legal understandings so maybe you can be provided a fair process. For this landlord, a fair process is impossible. Mafia rules apply. I do not know of an attorney willing to take on something like this. It is too complicated, and they are busy. Smash the like button for the YouTube algorithm. I do not know how to file appeals and submit evidence and argue case. I can research the Hello Kitty out of things but argue. Nope. I epically fail at arguing. I get frazzled, lose track of thought, and blank-minded due to past traumas. Read the hearing transcripts. You will see that happened to me in these proceedings. Sorry, landlord. I tried, but not an argue. I failed to communicate all this in court, and the printer failed B, so I could not show evidence in paper, and judge failed me as he did not accept looking at what evidence I had to show, and did not require the officials show documentation to support their statements. Yes, Mafia rules apply. This being said, landlord does not have money, but is willing to provide a percentage of damages to the attorney on contingency where damages are based on my calculations the following. Be sure to slow the video speed settings if you want to watch the video in a slower pace. Damages remedy. Loss of use rents and utilities. Over $97,000. January 2023 to present. 2 units, 2 bed, 1 bath each. But it is more because 1 unit was condemned May 2022. See February 1st, 2024, 9:43 email. February 1st, 2024, 9:43 email, etc. Loss of signed sale offer $230,000 plus closing costs $20,000 on August 1st, 2024, just 20 days ago due to officials' decision to delay justice, ignore calls, disregard landlord communications and actions, disregard my emails, and failure to provide occupancy certificate before the 1st of August. City dumpster hit and run damages to accessory wall repairs reimbursement. City unlawfully backdated and charged landlord $430 plus $630 for trash removal services never utilized. See May 18, 2023, 10:08 email. Landlord shall not by law be required to pay for services never received. Request reimbursement. Medical reimbursement of costs and pain and suffering, therapy ongoing appointments, fractured toe, shoulder torn rotator cuff, and knee issues caused to disabled landlord when officials hit and run landlord in their parking lot. Official was terminated, but their boss is the one responsible for harassment received that day and hit and run that resulted, but now condemned property here in this all. Did you notice? City officials and city dumpster trucks historically set the precedent of hit and run offenses against residents on multiple occasions, making this seemingly a common situation. Yes, a hit and run is considered a severe criminal offense normally. Legally, these officials should be fined for their hit and runs or imprisoned, not just terminated. They should not be performing them intentionally or with ill intent. What is this world coming to? Yes, Mafia rules apply. Smash the like button for the YouTube algorithm. Damages for the loss of landlord's previous home and forced homelessness for her husband, and 4 children caused by the same official when government took property from landlord which was nearly paid off in under 3 years. Property is an empty lot overgrown with weeds property today and brings down the value of neighboring properties. Fun fact, condemnation inspection for this property evidences photos after the property was forcefully vacated unlawfully under falsified pretenses that no one lived there, which caused insurance to drop landlord, which caused city to condemn and force landlord out. Yes, landlord family and the kids live there. Yes, Mafia rules apply. Normally, inspection photos must evidence the property is condemnable before forcing the landlord or tenants to leave. Here the landlord was forced out based on false pretenses, then the condemnable condition was only documented months later when no human was maintaining property because they were forced out. Yes, this mafia has no heart and may die a slow, grueling death. That, or they will continue on their path because justice does not come to pass for powerful individuals. Dad says criminals shall not be allotted normal jobs. Thus, one should never be present. Guess what? Criminals are president. This is because, yes, Mafia rules apply. Back to damages. Interest on damages. Compensation for government unlawful take for non-condemnable issues and significant financial impact caused in breach of the economic impact and takings clause, which states that when condemning the property would result in a significant economic loss without just compensation, it may be argued as a violation of the takings clause of the Fifth Amendment, which requires that the government provide just compensation for take. Case law in Penn's Central Transportation Company v. New York City for 138 U.S. 104, 1978. Also, case law in Lucas versus South Carolina Coastal Council 505 U.S. 1003, 1992. The Supreme Court ruled that if a regulation deprives a property of all economically beneficial use, it constitutes a taking that requires just compensation, highlighting issues of unjust enrichment by the state. Unlawful insufficient eviction damages awarded of just over $2,700 in damages the city court was to award landlord, but tenant appealed even though actual losses evidenced were over $12,000, and much of which I observed myself. The judge here had literally an entire inspection report evidencing damages caused by the tenant, and somehow decided the severity of allegedly condemnable apartment is only valued at $2,700 or so in damages, when rent is $1,200 and the tenant missed multiple months of rent, and did not pay utilities either. My point is, according to code enforcement, that property was condemnable due to just over $2,700 in damages, loss of rent, and loss of utilities. This means the condemnable damages were practically nothing at all, or a negative number in actuality. Sorry, I am thinking logically, maybe too much here. By definition, condemnable is sever significant and structural, but here judge had available the inspection report of officials who work in the same building and offices, but still decided only unfairly small award of damages. Sounds like another farce. How can you award so little for such a condemnable property, all evidenced by officials that work in the same office building? Yes, judge and official work in same building. For my property 20 minutes away, I proved Mafia rules apply when the judge and officials are housed in same building. Likely Mafia rules apply here too. Yes, this court hearing, landlord was steamrolled and abused by judge. Yes, Mafia rules apply. Will justice ever be provided? Likely no. Just like how this channel shows so much hard work, will it be subscribed to and watched? Maybe not. With all the hard work placed into each piece of content I post, better results would have been expected. Life is not fair though. We must simply do our best with what situation we are given. Gandalf always knows best. Damages continued. Pain and suffering, i.e. suicidal, family impacts, divorce, chronic stress, medical issues, etc. See April 17th, 2024, 2:56 email, February 23rd, 2024, 7:53 email, June 5th, 2024, at 6:09 email, etc. Harassment, discrimination, retaliatory actions, threats, verbal abuse, etc. Any other damages available based on case facts. For myself, exterior painting and landscaping in freezing temperatures and wind chill with disabled landlord, i.e. see February 23rd, 2024, 7:53 email that documents. Working on the list but difficult because owner is disabled and your list requires playing with dirt, stones, and scrubbing siding in sub 32-degree temps with wind chill and snow. Yes, I lived in Alaska and went to Antarctica. This moment here, painting in freezing temperatures, I marked down as insanity the officials required of the landlord. Then they continued delaying justice for many months, regardless of these efforts. See Wednesday, February 14th at 6:09 email. Wednesday, February 14th at 4:35 email. February 15th at 8:45 a.m. email. Items addressed/remediated. Email August 3rd, 2024, 7:40 email, etc. for evidence on damages. There is always endless evidence hypothetically because I am a data analyst, detailed individual, and geek. I do not pursue things unless they are ethically severe or pervasive. This you see in everything I post online. All is either positive and helpful or absolutely and totally wrongful. I just want you all to have a better life and better situations. I want the legal systems to change and improve. Nothing in life is fair. Would be nice for us all to be informed. Only then can we make the best decisions. This quote is paraphrased from a favorite leader of mine, Mr. Shackleton. Check out content about him in my business album content. Continuing on with things defined, I will give you something better. I personally would live in this property the moment it was cleared of tenants and the storage of materials. Specifically, before June 1st, 2023. Clearly, I could not reside there if another tenant is there. Boarding house, Airbnb, and B&B defined. Never any boarding house use or B&B use. Airbnb platform website use is not prohibited. No ordinances, codes, and standards prohibit the use of Airbnb website platform. No ordinances, codes, and standards prohibit it, nor are they publicly available. Short-term rentals are not prohibited based on my findings. No ordinances, codes, and standards prohibit it, nor are they publicly available. Property is permittable single-family dwelling that does long-term rentals. Judge allowed within proceedings for landlord to not understand issues, not understand claims, not understand arguments, or be provided documentation to support actual ordinances, codes, and standards exist. Today, landlord, and I don't have access to applicable ordinances, codes, or standards relevant to the citation fines. We're never allotted discovery. We're never given the verbiage of the citation at issue, so we could even know what the claim was. You can't argue if you do not know what you are arguing or what was cited against you. In court, I asked. They said numbers. I told judge, we do not know what the numbers mean. Judge did not care. I must have forgotten. Mafia rules apply. Let's define relevant definitions and sections. Yes, I should have said all this yesterday. All this content I had available to say. I blanked. Trauma hit me in the face. I failed to communicate. The transcript's evidence at all. More importantly, I presented official's case, but never allotted fair hearing to communicate landlord's case. Section 480.41 and Section 480.42 A. The property is encouraged for use as and may be utilized for permitted use of single-family dwelling. Once approved occupancy, Rental application would be completed to gain approval for this single-family dwelling/rental approval like all the other rental landlords in your municipality within this zone. This property is single-family dwelling for both units are both rentals and have been rentals since landlord purchased property and municipality never had an issue with it previously. Once approved occupancy, the property will be of single-family dwelling/rental use like other rentals within our zone in our municipality. This 2-unit property has 2 single-family dwellings where both sides have always been rentals since property was purchased in 2020. Never did municipality have an issue with it previously. The property was and will always be utilized for single-family dwelling use since 2020 purchase of property. As clarified by your code officer's email documentation, single-family dwelling is a permit approvable use within this property's zone designation. Boarding house. By definition, a boarding house is a type of residential accommodation where individuals rent a room within a larger house or building, typically with shared common areas like bathrooms, kitchens, and living spaces. Boarding houses provide long-term or semi-permanent housing, and unlike typical rental apartments, they often include some basic services, such as meals or housekeeping, as part of the rent. Key characteristics of a boarding house. Private rooms where residents have their own private room, which may be furnished or unfurnished, depending on the establishment. Shared facilities. Common areas like bathrooms, kitchens, and living rooms are shared among the resident. Meals. Boarding houses offer meals, often breakfast and dinner, as part of the rent. These meals are usually served in a communal dining area. Services. Additional services, such as laundry, might be provided. Community atmosphere. Residents often interact more closely with one another than they would in a typical apartment setting, creating a community-like environment. Examples. Traditional boarding house. Large home converted into a boarding house where tenants rent individual rooms and meals are served in a shared dining room. Modern boarding house. Small apartment buildings with furnished rooms, shared kitchens, and communal living spaces, catering to students or young professionals. Both units are always registered single-family dwelling use rentals for one single family for the unit where that family has the entire unit to themselves. This is a normal tenant situation. Never will the following be applicable. Never is a meal be provided. Never is anything shared. Instead, all tenants will have the entire place to themselves as a private rental single family to dwell and live. Never is laundry services be provided, because the rental itself has private laundry within the unit where it is a normal rental and single family has entire property private personal use. Never will individual rooms be rented. Never is more than one family or group be residing within a unit. Instead, use is for single family to dwell within one unit to have entire place privately to themselves. Never is meal to be provided or shared. Never are indoor dining areas be shared. Never is kitchen shared. Never is living room shared. Never is bathroom shared. Never is anything communal. Rental does not cater to students. Instead, property tenants prohibit tenants under age 23 as approvable candidates to rent. Never a unit be leased to more than one tenant at a time. Residents will have entire unit to themselves and not interact in a community situation. Never is laundry or meals charged to guests/tenants. Tenants provide themselves these as normal single-family use. Never are these services provided to a tenant. As evidenced, the property would be a single-family dwelling which is approvable for occupancy for this zone, and never will a bed and breakfast or boarding house be applicable to the property use. Never any violation. Never is prohibited in public codes and standards. Smash the like button for the YouTube algorithm. Bed and breakfast, B&B, defined. This property has never been and will never be a bed and breakfast. A bed and breakfast, B&B, is a small lodging establishment that typically offers overnight accommodations and a morning meal, with limited or no additional meals provided. B&Bs are often privately owned homes or small inns, and they generally feature a more personalized and intimate experience compared to larger hotels. Business model. Airbnb acts as an intermediary, connecting hosts with guests and taking a commission on rental bookings. A bed and breakfast, B&B, is a type of accommodation that offers overnight accommodations and breakfast, often in a more intimate and personalized setting. Property was never and will never be providing breakfast or meals. Property was never and will never be a bed and breakfast. Property will never have the capacity to offer meal services. Property was and will always be utilized for registered single-family dwelling use since 2020 purchase of property. As clarified by your documentation, this is a permit approvable use. Other properties utilize Airbnb platform to find tenants with no issues, as never is use of this website platform prohibited by codes and standards. Airbnb defined. As clarified, codes and standards do not prohibit the use of Airbnb website platform to find single-family dwelling rental tenants, and property always was a rental in past with never any issues, so there should be no issue for property to continue renting these 2 units as a single-family dwelling as they always did in the past with no issues. Others in the property zone and/or city utilize Airbnb website with receipt of no violations. Airbnb is not prohibited. It is only a website that markets the property to find tenants to include long-term single-family tenants. See here, I placed a 6-month stay minimum for my bookings. Yes, this evidence I can complete an Airbnb booking that is to a single family for 180 days in accordance with this landlord's apparent codes and standards, although we have no capacity to find the requirement publicly available online, so it may not be a real thing. Regardless of the fact, no one gave evidence that Airbnb is prohibited platform for us to use to find tenants long-term. The fact is I can book a permittable use single-family dwelling for 6 or more months that is not a bed and breakfast, as well as not a boarding house, by giving the entire unit to the guest and never providing meals to the guest. Airbnb bookings do not specifically provide bed and breakfasts. By definition, no, Airbnb is not the same as a bed and breakfast B&B, although there can be overlap. Here's how they differ.
Airbnb is a platform.
Airbnb is an online marketplace that allows people to list, discover, and book accommodations around the world. The platform offers a wide range of lodging options. Listings can include everything from single-family dwellings of short-term and long-term stays, where a landlord rents out their property. An Airbnb property does not have to provide meals. Instead, most do not offer the service. Most do not offer of breakfast or other meals. It is not a standard feature of Airbnb rentals. The focus is more on providing a place to stay rather than offering a full hospitality experiences. The locality zoning ordinance is allegedly available, but judge did not require officials to prove it when I proved otherwise. It is not publicly available in my findings and the findings of others as well. Officials in a court of law do not have to provide the defense codes and standards, ordinances, discovery, inspection report discovery, zoning ordinance discovery, or clarify what the legal ordinances state, so the owner can even defend against alleged claims. Officials do not read emails, reply, or clarify requirements residents are to adhere to. Thus, they will always lose in court. Mafia rules apply. You cannot win if you do not know what you are fighting. That is why in legal systems, the sections of statutes are cited but also quoted for the transcript. In this court, they do not cite and clarify the applicable verbiage of the described section. This is so you can't argue it. Good luck. Mafia rules apply. Imagine someone saying, "You violated Section 5B," then not stating what it is for. Good luck, Bob, when you don't know what the violation states. You can't have a fair hearing or trial. This is what happens in our municipality. You don't know what they are saying, and you don't know what you did wrong. You don't know the rules, so you can't implement them, so of course officials will find you in violation. You can't argue it. You can't seek justice or fair proceedings. It isn't possible. You are effectively taken advantage of by the experts who do this all the time. The judge is to ensure fair proceedings. When mafia rules apply, judges do not want the landlord to know anything. The less they know, the less they can hold officials accountable for fair processes and implementation of the law, ordinances, codes, standards, and code of ethics they are required to fulfill lawfully. Finally, a large reason why I say mafia rules apply includes the following: burden of proof for habitability or condemnations. This was an unlawful designation. See above definition and cited legal sections provided. Government condemnation of property. When a government seeks to condemn a property, burden is on the government to prove that the property is uninhabitable or poses a danger to public health or safety. Government must demonstrate that the property meets the legal criteria for condemnation, often by showing substantial serious violations of building codes, health regulations, or other safety standards. Government typically must present official inspection reports. Cosmetic issues are not habitability issues. Documentation of code violations. Property in great condition with no condemnable violations. Expert testimony regarding the safety or habitability of the property. Please give expert to prove unlawful designation. Yes. Records of complaints or previous violations. No historical violations in general. This is first violation ever for this property, and it is the most severe of all violations of condemnation. First offense and never any warnings or other violations for property. No precedent applicable to expect landlord to be someone who does not maintain their properties. As evidenced, the landlord never caused the violations here. The landlord has no violations evidenced before she was forced to vacate her 2014 home. Basically, by law, this same official cannot provide evidence that the 2014 property is condemnable because the inspection report for this has only photos after landlord was forced to vacate the property, which is not normal for condemnations. Normally, the property is evidenced to be in poor, serious, significantly condemnable conditions than the person's vacate. For 2014 property, the property was forced into condemnation with no burden of proof or inspection report justifying a condemnable property condition. Inspection photos are all months after no human resided inside and property was not maintained. Thus, condition caused by the designation, never caused by the landlord. Mafia rules apply. The city wanted the property condemned, so they get government grants for the demolition, and they rid themselves of residents they don't care for while also gain property ownership eventually. I wonder, who owns the 2014 property today? Comment below who you think owns this property today. Never violations or warnings before condemnation designations. No precedent. Same thing happened for 2014 property. Never any history of any serious significant violation or violations in general other that grass which everyone gets fined for at times. This is all based on my memory, which is very detailed and consistent when adversity strikes. Level up your life. Follow us on Medium to unlock our secrets. Subscribe to us on YouTube. Nothing within the inspection report sufficiently justifies a habitability or condemnable designations. Instead, officials sought maintenance of cosmetic, not serious, not significant items of landlord to gain approval of occupancy certificate. In accordance with Section 186 to 1AG, landlord completed all actions and rehabilitation actions city officials requested not just on August 19, 2024 occupancy approval date, but also previously by February 12, 2024 and December 20th. 2023 as evidenced by city inspections as well as in my findings May 2023 because landlord finally had tenants evicted to be able to clean up and perform normal maintenance to the property without being deemed liable for touching their personal property, clutter, trash, or items on the property. Landlord always with good faith intentions addressed all items the municipality officials requested even though requests were arbitrary, numerous, frequent, invasive, a breach of lawful search and seizures, and not justifiable nor necessary by law to gain occupancy certificate for the property. Efforts to mitigate. Landlord made reasonable efforts to address all items. Landlord remediated all listed items for resolution. Landlord's actions to remedy of any defects or issues cited within inspection reports and owner's commitment to maintaining the property is demonstrated. Case law, Griggs v. Borough of Jim Thorpe, 981 F. Sup. 527, Ed. Pa. 1997. The court ruled that a property owner who made significant repairs to bring the property into compliance could avoid condemnation. Here, due process and fair opportunity to make repairs before designations were placed was never provided to the landlord, and the landlord could not touch the property of tenants while they were at the property until official eviction proceedings of both tenants was completed, because the property of both tenants were the cause for officials' listed alleged violations. The officials placed the condemnation designations without any due process. The landlord could not remedy the items before the designation. The landlord did not have a list of items to remedy before the designation. The landlord could not lawfully remedy items until May 2023 when both tenants were officially evicted in court proceedings, and never was landlord allotted 10 days to address issues before designations were made. Furthermore, when the property was supposedly condemned by officials, when they listed the property specifically not habitable through papers placed on the door, the landlord could never resolve alleged violations because the officials placed stop work orders and required permits for actions, then never approved permits, although unlawful, even though permits by law are not justifiable based on the scope of work needed to maintenance the property. Due process violations. If the process leading to the condemnation or declaration of uninhabitability violates due process rights, the determination can be challenged. This includes issues like lack of proper notice, inadequate opportunity to contest the findings, or arbitrary enforcement of standards. Case law. The U.S. Supreme Court case Goldberg v. Kelly, 397 U.S. 254, 1970, established that due process requires notice and an opportunity to be heard before a government action that could significantly affect property rights is made. Due process violations are relevant and pervasive for landlords' 2014 property and this property. See April 28, 2023, at 9:41 email, etc. The habitability designation was always improper and unlawful. Never was any certified notice mailed to property owner. Instead, the habitability designation was placed on the door of each unit without any certified receipt of any notice. Never was owner provided written documentation listing items to address before any habitability designation was made. Never was owner provided fair opportunity to resolve alleged violations before habitability designation were made. Never did landlord understand the property was condemned when it was designated not habitable by the papers placed on the door. See emails evidencing all. Officials state the not habitable designation was just placed on the door, with no notice, no list of items to address, number 10 days to address issues before designations made. LS designation occurred on or around April 2022 according to August 20th. 2024 proceedings and RS designation occurred on or around April 20th. 2023, where it was reposted on the doors of both apartments for this date. See June 6th. 2023 at 7:13 email, etc. See May 22nd, 2023, 5:23 email, requested June 4th, 2023, 10:17 email, etc. Officials stated on August 20th, 2024, proceedings and not habitability designation is the same as a condemnation. The landlord never understood this. See Section 165 Part 15 to 16 of City's Dangerous Structure and Maintenance Ordinance stating, notice is to be provided, list of issues to be rectified, and 10 days to address items before designation is to be made. See Enclosed Ordinance clarifies 165 Part 2 minimum health and safety requirements for buildings, structures, or properties for human occupancy, which clarifies fair minimum requirements. Subchapter C, Section 6131A. 2. For permit denials by municipality states, A. 2. A municipality or board shall not deny a municipal permit to an applicant if the municipal permit is necessary to correct a violation of state law or a code. Officials improperly denied permits and through present never approved of permits for until June 28, 2024, when owner became more aware that habitability meant a condemnation designation because this designation was impacting the signed sale offer for the property. See May 18, 2023. 10:08 letter. Email. Landlord was forced to paint trim around exterior windows to gain occupancy within February 12, 2024 inspection. Painting of trim in sub 32 temps and wind chill froze my fingers in 10 minutes when paint is not recommended according to the can for these temperatures. Yes, I lived in Alaska and went to Antarctica, but felt the freeze and insanity of it all. This, as well as other requests, by definition is an arbitrary, unlawful request only required to delay justice. Disabled landlord, and I addressed the items anyway. I reapplied silicone to the tub myself. I think it looks nice. Of course, the tub had silicone. I just made it look nicer by adding silicone and cleaning it up, which the officials required us to do to gain occupancy approval. Smash the like button for the YouTube algorithm. March 28, 2024, 7:36 email officials won't approve permits for this property. Again, without approvals, there isn't any way to get work done. To resolve designation. Sounds unfair. Official threatened he would not approve of any permits. Thus, unlawfully owner has no ability to address items city wants addressed. Officials never approved of any permits January 2023 to June 28, 2024. Officials never provided landlord the how much the permit costs to obtain them. Thus, landlord could never pay for any permit until the June 28, 2024 permit. Officials placed stop work orders April 20th, 2024 upon front door so landlord could not correct list of violations in breach of subchapter C, section 6131A. 2. Clarifying permit denials shall not deny a municipal permit to an applicant if the municipal permit is necessary to correct a violation of state law or a code. Officials impacted landlord loss of use rent and utilities of over $97,000 April 2022 to present for the 2 property rental units, which caused financial pain and suffering and financial capacity to remedy alleged violations that were numerous, frequent, often newly added, but never severe or significant to justify any condemnation. Instead, violations were normal maintenance actions for properties and not to the severity of remedying a habitability or condemnation issue. Forced to buy another new stove because inspector did not like that it works well but must manually be lit with lighter. Property always had long handrail, which is sufficient to provide safety, but city officials forced landlord to add the rest to gain occupancy certificate approval. Smash the like button for the YouTube algorithm. Disabled landlord, and I scrubbed dirt off the siding then spray painted the siding under the window because officials required it due to it looking dirty. Again, here cosmetic scrubbing of siding and painting is required to gain occupancy approval, although arbitrary and unnecessary to gain occupancy approval. As clarified earlier, adjacent properties are in similar or worse condition, so this designation is unlawful. Based on the official's actions, most of the properties on Sand Street would be condemned if held to the same standard. Section 376 Part 13 Immunity of Enforcement Officers does not apply because officials' failure of reasonably good faith entry upon real property for 2014 for landlord's property taken from her, May 2022 for Sand St. left unit, April 2023 for 17 Sand Street right unit. Officials breached the code of ethics required by their credentials on multiple occasions and led to homelessness, pervasive loss of use, impacts to signed sale offers, pain and suffering, medical disability condition, and other irreversible damages to landlord. Section 165 Part 7 Duties of Code Enforcement Officer shall include actions to provide notices in writing, state reasons for notice being issued, provide reasonable time to rectify conditions, serve notice of dangerous designation, and an outline of remedial actions shall be listed. Never was a notice provided before designations were made. Never was landlord provided list of reasons for designation. Never was landlord provided list of remedial actions. Never was landlord provided 10 days to address issues before designation was placed. See emails i.e. May 22nd, 2023, 523 email, see May 18th, 2023, 1008 email, etc. Code officer and city attorney state in official court proceedings they ignore emails and do not reply to them, which further evidences their failure to perform their duties and failure to clarify codes and standards, ordinances, or provide discovery requested on multiple occasions. Yes, Mafia rules apply, and judges unlawfully allow it, which evidences unfair court proceedings. Officials admit to failure to perform their duties, which is evidenced on frequent numerous occasions. See emails, calls, permit requests, failure to provide payment amounts for permit requests so they may be paid for, failure to perform inspections, actions to delay justice, actions to foster unfair outcomes through never clarifying violations as well as codes, standards, and ordinances, failure to provide a copy of codes and standards or ordinances so landlord can review and know or implement them, unauthorized entries and trespassing, repeated failure to provide discovery of inspection reports, failure to write inspection reports for numerous inspections, etc. Failures and abusive actions delay justice ongoingly. See May 18th, 2023, 1008, June 14th, 2024, 2 o'clock email, June 14th, 2024, 2 o'clock email, August 13th, 2024 at 10:33, email, etc. Next, let's look at photos of neighboring properties and properties on our street, which is not too long, so it is easy to take photos of all, and see we are the best property on the street based on data given above, which evidenced on August 19th, 2024, landlord's property was of $244,000 value according to Zillow, which is tens of thousands more than all other properties in the area. March 28th, 2024, 7:36 email you. Won't approve permits for this property. Again, without approvals there isn't any way to get work done. To resolve designation. Sounds unfair. March 12th, 2024, 7:58 email officials keep adding new things for landlord to repair although the property is safe and structurally sound. Officials threatening abusive emails and communications i.e. February 15th, 2024, 143 email stating officials, email is threatening, continued abusive communications. Officials placed a stop work order on LS unit door May 18th, 2023, 1008 because property was utilized for storage and no work was ever occurring. Regardless, a stop works order and actions to not approve permits both synergistically impede justice, disallowing repairs to resolve alleged habitability or condemnation violations. Yes, this property has large holes in the roof, but is it condemned? Officials led to loss of use rents and utilities of over $97,000, which impacted landlords' income and capacity to afford repairing property and led to ongoing pervasive pain and suffering, i.e. physical therapy, medical disability issues due to truck hit and run by officials. Divorce this all caused suicidal tendencies, family pain, and suffering to entire family and all children. I accrued extensive credit card debts due to city actions because landlord had no money for the numerous items officials asked her to remedy when I had no money either. Ongoingly, officials were always adding new items for remedy within numerous frequent inspections without oversight because officials do not draft inspections for each and every visit. This is only common practice, but not for officials here. Instead of providing occupancy certificate when property was livable and safe with all basic amenities, which it always had. Also, no structural issues existed to justify any habitability designation or condemnation, as the accessory wall was only a repair within the existing footprint with similar materials and caused by city officials' hit and run. Condemning property for something city officials unlawfully did would be blatant retaliatory, discriminatory action performed only to harass landlord and delay justice. Repeated requests for city officials to halt discrimination, harassment, retaliation, breaches to code of ethics, and unlawful delay of justice May 18th to present, etc. are disregarded and ignored by city officials and city attorneys CC'd on emails. I requested city officials to abide by permit fee schedules they are to uphold and not fail to uphold this by forming unjustified permit fee amounts from Google estimations instead of actual repair costs unlawfully in response to their actions. See May 18, 2023, 10:08 email. City unlawfully backdated and charged landlord $430 plus $630 for trash removal services never utilized. See May 18, 2023, 10:08. Landlord shall not by law be required to pay for services never utilized. Never reasonable or amicable. City trash truck hit and run damages to accessory wall to coercively condemn property, then never reimburse landlord for repairs to accessory wall through present. See emails. Historically, government officials hit and run against accessory walls and fences all the time throughout our area and in Pennsylvania in general to unlawfully condemn properties in an abusive, unlawful manner. City officials should not be allowed to condemn properties for issues they themselves caused. Smash the like button for the YouTube algorithm. See photos of next-door neighboring properties. Economic impact and takings clause. If condemning the property would result in a significant economic loss without just compensation, it may be argued as a violation of the takings clause of the Fifth Amendment, which requires that the government provide just compensation for take. Case law in Penn's Central Transportation Company v. New York City, 438 U.S. 104, 1978. Also, case law in Lucas v. South Carolina Coastal Council, 505 U.S. 1003, 1992. The Supreme Court ruled that if a regulation deprives a property of all economically beneficial use, it constitutes a taking that requires just compensation, highlighting issues of unjust enrichment by the state. Section 370 Part 1 officials are to ensure that structures are safe, sanitary, and fit for occupancy and use, and the condemnation of buildings and structures unfit for human occupancy and use are always structurally safe and fit for occupancy or use. Arbitrary or discriminatory condemnation. The designation of not habitable or condemned was an action taken in an unequal, arbitrary, or discriminatory manner as demonstrated by other properties in similar or worse condition were not condemned, or that the condemnation was based on factors unrelated to actual condition of the property, i.e. here, based on sex, disability discrimination, to harass, and in retaliation. Unfair condemnation. Neighboring properties with similar conditions have not been condemned, thus condemnation is arbitrary or discriminatory. See comparable evidence provided. Comparative analysis of the conditions of neighboring properties provided. Evidence of discriminatory intent or arbitrary application of laws provided. Testimony or documents revealing inconsistent enforcement practices provided. Also see testimony, emails, etc. Yes, historically officials take discriminatory actions, may be terminated for hit and runs, harass outside their jurisdiction for regarding my property 20-minute drive away, etc. Preponderance of the evidence, to convincingly demonstrate that the property either meets or fails to meet the required habitability or safety standards, justifying or challenging the action taken, applies here. Section 165 Part 4 defines a dwelling as any building intended for use, for sleeping of human occupants. Section 223 Part 8 clarifies no occupancy permit may be issued for any dwelling until the City Code Enforcement Officer is in receipt of a certificate governing inspection and indicating that said work complies with the requirements of the Uniform Construction Code, and this chapter which was completed and received August 15, 2024. Yes, delay of justice was very effectively achieved by officials here. Section 186 Part 2, b. When rehabilitation of the condemned property is complete, the following actions must be taken for condemned property is released from condemnation. 1. The owner must contact licensing, inspections and permits, and schedule a final inspection of the property. Completed. Officials delay justice. See emails. 2. The owner must obtain a certificate of occupancy for the property. The property will not be released from condemnation until a certificate of occupancy has been obtained. Awaiting through 12:20 p.m. August 19, 2024. As this all happened today, check out photos of the property, just approved occupancy yesterday, although it was habitable and not condemnable since I have been overseeing property May 2023 to present, as well as unjustly deemed not habitable or condemned before I began overseeing actions of officials. Landlord was forced to perform cosmetic painting of the top portion of the back and front of property siding shingles last week to get approved for occupancy. Yes, more new cosmetic painting added and required to gain occupancy approval, even though not necessary for occupancy. No one even sees this, let alone does it affect the livability of the property or safety of occupants or public. Maybe our neighbor should be condemned until they paint top front siding too? Yes, this property on Landlord Street is in worse or similar condition, but never condemned. Comment level up to show you are ready to level up and read this article to the end. In general, the landlord would have said, except the judge did not allow them to speak within August 20th, 2024, court proceedings. Evidence of unfair hearing and actions by the judge. Your Honor, I am writing to assert that the city has violated my rights through unfair and unreasonable enforcement of zoning laws, resulting in significant financial and emotional distress. Under Pennsylvania zoning laws, municipalities are required to enforce regulations consistently and without bias. However, in my case, the city has acted in a manner that is both arbitrary and discriminatory. I have made every effort to comply with the city's requirements, including actions to obtain permits and completing numerous repairs to my property. Despite this, the city has repeatedly moved the goalposts, making it impossible for me to regain the use of my property and resolve any habitability or condemnation status. Furthermore, the city's zoning enforcement has hindered my ability to earn a living. The prolonged condemnation and the city's delays have deprived the ability to rent out the property. Later in July 2024 also deprived me of selling the property in the offer I accepted. I have had substantial financial losses. This inconsistent and seemingly punitive enforcement contradicts the principles of fairness and equal treatment enshrined in Pennsylvania's zoning laws. I also want to highlight that while I have complied with all demands from the city, the surrounding area remains neglected, suggesting a selective enforcement of zoning regulations. This differential treatment raises concerns about the city's motives and adherence to zoning laws, further supporting my claim that the city's actions have been unjust and unlawful. I respectfully request that the court recognize the hardship I have endured due to the city's actions and consider the violations of my rights as outlined above. Thank you for your attention to this matter. Thank you. Landlord's signature dated August 20th, 2024. Court proceedings end here. Comment level up to show you are ready to level up and watch this video to the end. Comment below what do you think about all of this. If you have words of wisdom, let us know in the comments below. I would love to get a debate in the chat about all this because learning and growing often starts by listening, communicating, improving, and taking repeated actions to the best of your ability. What do you think about the Mafia rules apply concept? Do you agree things sound off? Do you agree this all looks unlawful? Have you experienced things like this? What did you do? Let us know if you have any stories about this type of thing. I always think stories can be helpful, a great way to learn and help others, which is the intent of this content. As you can see, I made all anonymity focused and aimed at educating and informing on my findings, which I extensively researched and did my best to objectively communicate. Thank you for joining me here. I greatly appreciate all likes, comments, and follows. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. Please do like, share, subscribe, and comment below to help support this channel and help me succeed so I can post more for you. Thank you all for joining me. Talk to you soon on the next one. Click on the on-screen images to subscribe and watch more videos.
Just gotta flip the switch and you can go and obtain anything you want, anything you need. Your mind's got the key ingredient, it's belief. Even when you feel low, you can still go. Even when you feel slow, you can still go.